So it's not as common as perhaps mediation?
Right, mediation is much more common.
Tell us how you define mediation.
Mediation is defined as parties and their attorneys, or parties without their attorneys, getting together with a mediator. Now, a person may feel uncomfortable not having their attorney present at mediation, and if one person wants their attorney there, both attorneys have to be there representing the parties, because no competent mediator will allow there to be a mediation with only one party represented. A mediation involves sitting down with a person designated as mediator. Again, it could be a family law attorney, it could be a retired judge. Those are your two best options. And that person is normally paid out of the marital funds or paid by each of the parties out of their own separate accounts. The mediator will hear each of the people's needs and concerns and try to avoid having positions be polarized and making a decision on the case for the parties when they can facilitate conversation instead and help the parties have discussions so that they can reach their own conclusions about their future. As many judges will tell you, if a matter is heard by the judge can learn very little about the family and the amount of time that a court can take to allocate to a family having their matter heard. A mediator might take 2 or 3 hours just to become familiar with the parties, familiar with the facts, and hear things, hear angles that can be pursued without the necessity of any sort of trial atmosphere. Some people give the example that a mediation can work as it would if people were arguing over an orange, and one person in reality wants the peel and the other person wants the juice. And if someone didn't ask enough questions to figure that out, they may be arguing over this orange until the orange is completely destroyed and no one gets an orange.
That's a good analogy.